The victim sucked the defendant's penis for about 2 minutes. The defendant had his right hand on the back of his neck, and if he tried to sit up, the defendant pulled him back down. This ended when the defendant ejaculated in the victim's mouth. The victim turned to the right, opened the passenger door, and threw up.
Welcome to Bench Report Court Cam.
Or does call the case People State of Michigan versus Zachary Radcliffe. Counsel, state your appearances.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
James Thomas on behalf of Mr. Radcliffe, Your Honor.
All right. Mr. Thomas, this is the defendant's motion, so you may proceed.
Thank you, Your Honor. Would you prefer me at the podium, or since I'm spread out here, can I do it?
Either way.
Judge, I'm going to start off with just talking about where we're at as far as this motion is. As you're probably aware, my client's been incarcerated for about 105 days at this point. He currently has a $3 million bond, which under the circumstances I feel is unreasonable. And I think that once we talk a little bit about what the evidence is in this case, because obviously part of our burden under the law is to show that there isn't a great amount of evidence, or that the presumption is great, that the evidence of guilt is there. And to go through that, Your Honor, what I'm going to do is I'm going to kind of surmise the evidence a little bit here from what we've looked at. And I would tell the court, as of just yesterday, I just received another supplement in regards to this case.
All right.
Of course, the last time we were here on the 9th of January, I believe, I think that was the last PCC. The last time we were here, I had asked whether there was any other outstanding warrants that were involved or anything. And then I became aware that now I guess there's some Snapchat warrants. But at any rate, Your Honor, just to go through a cursory account of what I believe is not great evidence or a presumption of guilt in this case in regard to the evidence, simply would turn and talk about the FBI report that was given to us, where one of the victims in this case went to the FBI to lodge a complaint, which was really the beginning of this case. And upon a cursory review of that particular investigation that was conducted by the FBI, they found that they didn't have any Facebook or YouTube channel or Instagram. Everything was negative or for derogatory information in regard to that. Notwithstanding that, and again, this is me reading this report, that this allegations that were made were like multiple sessions that allegedly occurred. But when the investigation went back to the state police, it's one time. So there's a difference in that, and obviously there's no evidence that it's years ago, over 10 years ago, whatever it was. So that was the beginning, which led into other things. Going into an investigation for Yahoo, and going into his email address, going into all these videos and whatnot that were alleged to have been passed back and forth between the different alleged victims and whatnot. There is no CSAM. So there's no CSAM in this case that is in my possession that I've seen at all. And obviously that's a problem, because back in November, as you're aware, there was a 12 count complaint that then turned into a 31 count complaint. And the magnitude of charges doesn't make this case any more significant. You can't continue just to stack charges when you don't have the evidence to prove that CSAM. They need CSAM to prove their case, and they don't have it. They don't have any of this stuff. So the presumption, the evidence of guilt is not there. And again, I'm going to get into the other part of the hurdles of this case, but it's not there. We don't have any of this stuff. Going to, again, looking at the Google ones that were sent out, nothing. There's no evidence in regard to any of these transactions that were allegedly occurring between the people that are involved in this case and the defendant in this case. Now, the court is obviously well aware that when you're charged with capital offense, obviously part of this for us to show that there's a lack of this evidence. Well, we got the response from the prosecutor's office yesterday in regard to our allegations, in our motion. And I'm sure the court, I don't know if you've had an opportunity to review it or not at this point.
I have.
But here's the part that I have a big problem with, Judge. When 6, 7, and 8 are the meat and potatoes of our motion, which the prosecutor's office answers they can either admit or deny. And obviously, you can't admit or deny and then put that we need to show our proofs on this totally shifts the burden to us. We don't have a burden. The standard of proof for us is nil. We have to prove nothing in this case, Your Honor. And I find it kind of, as a 28-year-old lawyer, I find that kind of disingenuous. The answer being either we don't admit or deny when you have a 31 count complaint that my client's facing with a $3 million bond that can't get out of jail is not reasonable. I just don't think that that's right. If you're going to deny something, that's fine. I don't have a problem with the denial, but not admitting and not denying as to the basics of why my client is incarcerated, I have an issue with. And so I want to, I hope that the court will take that into consideration, when considering whether or not we've met that, met the standard that this case does not have the evidence that it needs to continue to hold my client on a $3 million bond. The court was given, today, I don't know if you had an opportunity because there was 11 letters that I submitted as a supplement this morning, Your Honor.
Counsel,
I
you haven't been before me, but I read everything. So yes, I've read.
Okay. Well, and I appreciate that, Your Honor. I also, and I don't know if I showed this to the prosecutor. These are like 6 or 7 more letters. I don't expect you to read them right now, Your Honor, but can I approach it as,
Any objection to the court receiving the additional letter?
Judge, I have a copy of them. I can later on do another supplement and admit them
All right.
to the clerk's office, Your Honor. So let's talk a little bit about the flight risk. And I think that, with the danger of the community and whatnot, the things that the court would be concerned about, obviously, to make sure that my client shows up for court. So we have all those letters of support. As far as my client goes, he is a lifelong resident here in Michigan. He's never lived anywhere else. He doesn't have a passport. He doesn't have, he's indigent.
Didn't he live in Virginia or no?
No, he never.
No. Okay.
He went to school there, but when you're a student, you don't have to.
Yeah, but I mean, he was there at Liberty, right?
As
Or
a student,
no?
I believe, Your Honor.
Okay, okay. I just want to make sure that while he may have been a Michigan resident, there were periods of time where he resided out of state. Is that right?
It's fair enough. Yeah.
Okay. All right.
That's fair. I've always known it, whether you're in the military or if you're a student out of state, you're not really a resident of that state unless you claim to be a resident of that state. Because you don't have to get a driver's license from that state if you're either in the military or you're a student. I don't know if the court knows that or not, but I know
I attended school out of state. It may have been back with the dinosaurs, but same rules apply. Go ahead.
All right. Well, his ties to the community, obviously his family, friends. I mean, he has all these people that are sitting in these rows here in his support here today, Your Honor. I'm sure some of them that are here wrote some of those letters. He's not going to be a flight risk. He's not going to be going anywhere. And, obviously I'm his attorney, and I'm going to be on this case to its conclusion. He doesn't have a history of any alcohol abuse or drug abuse or anything like that. He's never even used any of that stuff. There's allegations from some of the people in this case that he has, but there's absolutely zero evidence of that. And obviously, my client would obviously tell you that he does not have any issues whatsoever with any of that stuff. And he doesn't have a criminal record and no juvenile record in furtherance of that. So these are things that I think would be important, to the court. Obviously we feel that he could get a job doing something if he were to get out. He doesn't even need to stay in this county. He has a sister who lives in Lenawee that he could stay with if need be. And obviously the other thing would be, if he needed to wear a tether or something like that, he would be, he would do anything the court would require him to do. I'm also going to talk a little bit about, the risk, the outside risk to the community, and again, just because you file a magnitude of charges on somebody doesn't mean that you can file 100 charges on somebody. If you don't have the evidence to prove those, you can't just say, well, the magnitude of charges merits a high bond. That's ridiculous. It shouldn't work that way. Bail doesn't work that way. I would also cite the court to a case, which is the People versus Davis. It's a Michigan Court of Appeal case from 2021. Basically, that under Michigan law and under the Constitution of our state, that you have a right to reasonable bond and reasonable bail, and based on your circumstances. And my client's indigent at this point, so a $3 million bond is tantamount to zero bond. I mean, even if it was $1 million, it's still tantamount to no bond. Well, lastly, Your Honor, I'm going to talk a little bit about, we had an evaluator go in there, PhD in psychology, Dr. Schaefer, Kathleen Schaefer, who I believe, and I'm not from Washington, but my understanding from my communication, unless I'm wrong, that she's been a doctor for the prosecutor's office also, and so in Washington. I don't know if that's true or not, but I believe that that was something that she proffered to me. But she's also went in and saw my client. I attached the 4-page report. I'm not going to go into the report, read it to you or anything. But obviously, he's a very low risk for repeat violence. She scored him as low on everything, pretty much, Judge. And obviously, we had that done for the reason of this hearing. And I think that, taking that into consideration, the court can certainly take other measures to make sure that if he were released on some type of bail, that, no contact orders and all these other things that the court has an absolute right to implement and put on my client, to make sure that he's going to not only comply with the court's orders and showing up in court and doing what he's supposed to be doing while this case is ongoing. But also, obviously it would be a great help to go through this evidence and prepare for this case, in the upcoming court date. And that's going to be very important to our defense and being able to be properly prepared to defend this case. And again, Your Honor, just, looking at the evidence, I submit to this court that you can point a finger and collaborate and do whatever you want, but just pointing the finger, it's just an accusation at this point. And accusations where the investigation that was conducted in this case, with all these things that were supposed to be passed back and forth, that not one thing has been passed, either from him, which would also, which I didn't bring up, but which also would include a VHS, a camcorder, 7 VHS that were found in his house. And he had no time to try to hide anything or clean anything up or do any of that stuff. His house was search warranted, and they went in there and confiscated all this stuff and still didn't find anything. So on top of that, Your Honor, I would just say that, obviously, if the people that are making the allegations said that they sent things through ISPs or IP addresses and through their email or through that, and yet the prosecutor's office has had the opportunity to do all these things, subpoena all these records, try to get all this stuff and not be able to produce one piece of solid evidence and then say, well, we don't admit or deny to any of these allegations. It's because they can't, because they don't have the evidence. So, Your Honor, I'm asking the court today that, what I would think would be a reasonable bond for my client would be, $10,000 in that range, and possibly, if I think a tether or anything else would be he would be amicable to any of that, Your Honor.
All right.
Thank you.
And
Yes, sir.
had a couple quick, and so that you understand both parties, sort of what the court's analysis and looking at the issue of danger to the community and the flight risk. When I go through the prosecutor's response, some things kind of jump out at me. Okay. One of those being, I mean, there was a lot that kind of jumps as it talks about the particular victim. But when the behavior as I see it laid out is certainly, I mean, and I know they're going to have to prove their case, but is very predatory in terms of sort of the connection of the alleged victims in the case. Okay, so that's one issue that is the court. One of the other things that the court takes into account, because, you know, unless there's been some prior behavior on the defendant in terms of that they're going to, that they have fled or not appeared for a court proceeding or those kinds of things where the court can see past behavior directly related to the court. One of the things that the court looks at is, does the individual do things that in the court's mind may either lead or obstruct an investigation or do something that might be obstruction of justice? So that's something that, and I would tell you that the court looks at that. Where I weigh it depends on the particular case or the nature of the case.
Do you have an example, Your Honor, of what you're talking about?
Well, if you look through the prosecutor's response, there were, and I guess I wanted to get the defendant's response to it, which may just be it didn't happen, but there are indications that during, and at what point in the investigation, I'm not sure, that there were calls or communications from your client to individuals that are now alleged victims in this case, to, if they're contacted, to not say anything, or if contacted to support the defendant.
Right.
And there were at least two or three.
And what I would say, Your Honor, is there's
Go
cell
ahead.
phone records that should exist. If my client called them or vice versa, then the cell phone records that in 2024, pretty good. You know, if the prosecutor's office thinks that my client was calling them and telling them that, then produce those records. Say,
Well,
here's that.
but counsel, you know, I get it, but I'm not at the point of prelim or that. I'm looking, you're asking me to reduce bond. There are certain things that I'm looking at that I'm telling you that cause the court alarm. And one of those things is, if that happened, that's a huge red flag to me. And it sort of counter, or at least counters one of the things you said about the existence of evidence in his home or not in his home. Because at some point, what's clear to me is that at some point during the course of this investigation, the defendant became aware that something was afoot. And I'm putting it that way because I don't know if he became aware he's under investigation or became aware of whatever. It may have been, maybe he was contacted by the FBI, if that was the initial part of this, whatever. But then it wouldn't make sense to me why he would be, at least that's what's alleged here, contacted by these individuals or contacting these individuals to say, do X or do this. I mean, the statements that are in there they're not, well, we talked to police, tell them the truth. They're not sort of these innocuous things. They're sort of directives of what the individuals should do.
And you said it quite clear. If it's true, if the court doesn't have any evidence of that other than what's written on a piece of paper, and if they wanted proof of that,
but counsel, that argument is fine, except, you know, I need some type of response to that. Because it can't be, well, do the people have this evidence? Because if that's the case, if I take your analysis, that means in every case, despite any rule, despite anything, people just get released on everything. I realize that this is something that is fluid and that evidence kind of moves along. But I'm asking at some point, maybe the prosecutor argues first and then you can respond to it. But if you look at the particular provisions in the prosecutor's response, there are indications at the end of a few of the paragraphs where they're talking about the victim or alleged victim being in contact with your client, and that there is then the allegation that there are specific instructions about what that person is to do when contacted. So I'll let you look at that, counsel, and I've got it as I
Can I
indicated.
ask exactly where, what page is that on that you're looking? I've read through this a couple times, so I know it's in there. I just don't know where it's at.
For that portion. Right, I don't know if you can help me. There were two of them. Oh. Victim D and B is one. And the next one, victim E, the reference at the bottom,
Is there a page number on?
page 5. All right, as I indicated, the court needed to take a break at 4 o'clock to make that call to the court urgent that I have to do. So the court's going to stand in brief recess. And
All right.
All right. Right.
Yeah, he's ready.
Back on the record in the case of the People versus Radcliffe. Counsel is present along with the defendant. Thomas, you may proceed.
Thank you, Your Honor. And Judge, I'd just like to address what we were last talking about before you left. And,
Yes, sir.
as page 5 with victim D and victim E. And I went back and I've looked at these things. And again, Judge, if the court has any, any concerns regarding my client with that type of contact, the one thing I would remind the court of, one, if it did happen, then I would say, obviously he wasn't under a court order or anything at that point. And so I understand the court's concern, but we would be willing to, have no contact orders, take away, and give up on any electronic devices, no phones, no computers, none of that. And I think that would obviously put to rest any possibility of him. And obviously, if he violated that, he would be right back here in jail. It would not be wise for him to do that. It wouldn't be wise for him to contact that. And honestly, Judge, it would be contrary to what I would advise him to do.
Well,
So
right. And let me make myself clear that I'm not saying that he violated a condition of bond. I'm not saying anything along those lines. I'm saying what troubles the court is that behavior where there are these allegations that are out there, and then behavior to, so I'll put it in the colloquial, just to either cover up or interfere with and or obstruct an investigation. That's what bothers the court. I'm not saying that he should be charged with anything. I'm not saying that. I'm just looking at the behavior of the defendant, because that's what I've got to bank on if he were to be released. And I'm pointing out what at least is alleged, a behavior that is very troublesome for the court.
And does this go to risk to the community, Your Honor, that you're talking
It
about?
certainly goes to risk to the community, and in my experience, also would go to the issue of, can I trust this person to not flee? Because in some way, this can amount to some type of obstruction of justice or some type of interference with the investigation. And do I believe that that person, assuming, and I'm not saying, not trying to necessarily make an accusation, but if somebody were to do that, can I trust that person not to flee the jurisdiction?
And again, Judge, I'm sure you've been doing this a long time. I've been doing this an awful long time myself. I've had, this is not my first bond hearing. I understand the court's concerns, and under the circumstances when you have somebody that's got no prior criminal history whatsoever, you've got somebody that's never lived outside of Michigan per se, other than being in Virginia for Liberty for school for whatever that time period was, that has lived here his entire life. His entire family resides here. He doesn't have a passport, so it's with the lockdowns that they have today, I mean, it's probably pretty impossible to try to get off out of the United States without a passport. And obviously going anywhere else in the country, with the computer system, the NCIC, and everything else that's out there, makes it almost impossible for somebody to just disappear and never be found again. It doesn't happen. I mean, I don't think I can think of one case where I've ever seen as an attorney where somebody didn't show back up.
But counsel, it isn't even the issue of will they be found again. It's the issue of will you attempt to try to flee the jurisdiction. I mean, and it's a slight distinction, but there's a distinction in it. So
I'm just saying, Your Honor, with the bullet points that I've already presented to the court, that he's not an alcoholic, he's not a drug abuser. He's had a job his entire life. He's got family and friends here. There's nowhere for him to flee. He's not going to flee. I don't think the court has anything to worry about with the fleeing portion of this. And I don't say that lightly, Your Honor, because I understand the severity of these charges. I get the concerns of the court, and I don't take that lightly. I don't take my position as his attorney lightly in that matter. And so, I drive 2.5 hours to get here every time I come here. I certainly don't want to represent a client that I would think is going to flee the jurisdiction and not do what I'm telling him and directing him to do. I certainly would direct him to make sure that he's in court. He knows what the evidence is at this point, Judge. And I told him, obviously we're here to defend this, and he's here and he wants to defend it. And obviously that is our goal, is to get through these PCCs, get through the preliminary examination, and let the chips fall where they fall. When we get through the preliminary examination, then if any charges that still exist after a preliminary examination, then we'll deal with that in circuit court. So obviously, our position as Judge is that he's sitting in jail for 105 days. The evidence in this case just to charge people with CSAM and not have any CSAM just doesn't make any sense to me. And then to file more charges for the same charges without knowing that you didn't have any CSAM doesn't make any sense to me either. So in light of all that, Your Honor, just the magnitude of these charges that are presented on top of him doesn't mean that, hey, there's more charges I'm going to take, possibly be a flight risk or a danger to the community. He wants to face these charges. He wants to exonerate himself. That's what he wants to do. And so with that being said, Judge, my client is going to appear for these court dates. He's going to appear with me. And again, he's got all these people that are supporting him. He's got the letters that were presented to the court. He's got a place to stay, and we will give up any electronics. We will give up anything the court wants. If you want to put a tether on him, we'll put a tether. We'll put him, no contact orders. Take away all electronics. Anything that the court would make it feel safer for him to be out. He's going to get a job, and he's going to go to work, and he's going to live with his family. He doesn't need to have access to any of that stuff. So the court can put those no contacts, and if he violates, then throw him back in jail and keep him there. I have no problem with that.
all right. Thank you. Ms. Rice.
Thank you, Your Honor. I would indicate to the court that the defendant was arraigned and arrested on or about October 20th, 2024. At that time, Magistrate Fink set the bond at $3 million, no 10% cash or surety. Once the defendant was arraigned, additional victims did come forward. At the time of arraignment, he was charged with 1 count of criminal sexual conduct in the first degree, with 1 listed victim and additional approximately 11 additional counts of child sexually abusive activity and using a computer to commit a crime with different victims than the listed victim for the criminal sexual conduct first degree. When the additional victims came forward, the defendant is now, after the arraignment and the bond being set at $3 million cash or surety, facing 6 additional counts of criminal sexual conduct in the first degree with 2 separate victims. And I state that because the court rule in the statute allow this court to deny pretrial release of a defendant charged with criminal sexual conduct in the first degree if the court finds the proof of the defendant's guilt is evident or the presumption is great, unless the court is presented with clear and convincing evidence that the defendant is neither a flight risk or a danger to the community. And I would submit to you, first and foremost, Your Honor, there was no abuse of discretion in the magistrate setting the bond at $3 million. But if we're going to look at the bond that was set at $3 million, the things that have changed since that bond was set is additional victims have come forward. So it would not be appropriate to reduce the bond. And in fact, the people are requesting that the bond be denied because there's no clear and convincing evidence that the defendant is neither a flight risk nor a danger to the community. This information in the investigation began on or about August 26, 2024, when it was reported to the police department, to MSP. One of the victims reported to the defendant's girlfriend at the time the things that the defendant had done to him. When his girlfriend at the time confronted him about that, confronted the defendant, she had a 6-hour longer conversation that night discussing the victim that had come forward. The defendant told her not to believe a word that he said, and he left her house around midnight. He told her that it was best that she not tell anyone that the majority of their conversation was about that victim. And he reminded her that they still had a 2-week break left in their relationship and not to contact him. Another victim came forward, and that's when she broke up with him. After that conversation, on August 30th, 2020.
Excuse me one moment, sir. Counsel, when you want to talk to your client, make sure to push the button on the top.
Yes, sir.
These microphones are very sensitive and I don't want a conversation.
Thank you.
All right, go ahead, Ms. Rice.
On August 30th of 2024, the defendant then called that victim 8 times and told him that he needed to keep his, quote, fucking mouth shut, end quote, because there was no information that he could tell Brianna. And that's referenced in page 8 of the people's motion. So this is information that the defendant, that we have during this investigation. This is how he's acting when he's not been charged, when he's not been arrested and not been arraigned. He is intimidating and threatening the victims. And I would submit to this court that he is a flight risk. During the investigation, on October 21st, 2024, the Michigan State Police interviewed the defendant's parents. He was informed by the defendant's parents that the defendant went to Virginia after news of this broke. He may have stayed with his college friend Phil, whom he knew from Liberty University. His mom thought that she went to stay with her sister Rhonda in Indiana after he left Virginia and gave Rhonda's address. Rhonda dropped off 2 suitcases of Zach's to Frank and Robin. Frank went through the luggage and found a MacBook inside. The trooper took custody of the laptop. Robin and Frank did not know the passwords to any of the devices. The defendant
So-
cried during the interview and said that Zach had been leading a double life.
Counsel, I don't want to interrupt you, but I want to make sure that I'm understanding this. In October of 2024, the defendant, after the investigation starts to happen, he leaves the state to go to Virginia.
Correct. Around the time that the news broke, but before he's been arrested or arraigned, he left and went to the state of Virginia.
Okay, so when you say the news broke, when it became public,
I don't
Or
know exactly
news.
when they referenced, but I'm presuming sometime in the end of August, beginning of September, when everyone in the community, the church community,
Got
and the victims started coming forward and reporting to the police.
okay, and so he left the state, some thinking that he's in Virginia, others thinking in Indiana, irrespective of that. For how long a period in time was the defendant not in the state?
I don't know the answer to that. They had just started to take the investigation and interview these victims. And when he was ultimately arrested, when the police arrested him after the conversation where he made admissions to one of the mothers about having these boys send him pictures of themselves masturbating, and he would pay money for them. When he made those admissions that are on tape that will be played at the preliminary exam, he was driving a rental car and had multiple electronics in the rental car that were seized. So that is our evidence, our indication that he is a flight risk. So
Well, and I'm sorry, but the rental, or he was arrested in the state of Michigan.
correct.
All right.
In what?
In a rental vehicle
Dundee, in a rental vehicle.
in Monroe County, down in Dundee.
Yes.
All right, go ahead. I'm sorry.
So that is just some of the information that the people believe that the court can consider and show that he is a flight risk. Beyond that, Your Honor, counsel talks about just because of the number of charges that the people bring doesn't affect bond, and I think it does. In this case, the allegations are, and the evidence will show, that the defendant abused his position of authority at the church. So it's not, we don't have one victim or two victims, we have multiple victims spanning over a year period of time. So he is a danger to the community, and the people's position is, if he were released, he would be contacting these victims, and there's nothing to stop him from contacting. Sure, there's a court order and we can violate his bond if he does it, but the appropriate thing in this case, and the multiple counts of criminal sexual conduct in the first degree, allow for this court to deny the bond. And that's what we're asking be done. The statute, the jury instruction on criminal sexual conduct in the first degree concludes that to prove this charge, it is not necessary that there be evidence other than that of the victim, if that testimony proves guilt beyond a reasonable doubt. So the victims of the criminal sexual conduct can come here and testify at preliminary exam. They can testify at trial, and the defendant can be convicted on it. There's not one victim of criminal sexual conduct in the first degree, but there are three. And so I don't believe it was an abuse of discretion to set the bond at $3 million. I do believe, based on the evidence in this case, that he is a danger to the community, and moreover, a danger to the victims in these cases. So I don't think it should be reduced. And we're asking that, pursuant to the statute and pursuant to the court rule, that it be denied.
Thank you. Response.
Yes, sir. So going back to the arraignment when he was actually given the $3 million bond, obviously the court didn't have access to what we've given the court, which is the doctor's report for one, you know, the letters of support and all these other things that are out there. Two, you know, there was no discovery that had even been conducted at that point. So whoever the attorney was that was arguing on behalf of my client at that time didn't have anything really to hang a hat on to make any kind of argument whatsoever at that time. But some of the things that the prosecutor just said in regard to this investigation in October she doesn't know what the dates are when he was gone, when he came back. He came back to face the charges. He wasn't arrested somewhere else. He drove back here to face the charges. So he's not a flight risk. If he was a flight risk, he would have stayed where he was at. He obviously came back here to do the right thing, and that was to face the charges. And he cooperated with law enforcement. There is absolutely nothing that the officer in this case wrote in his report to say anything other than, he was cooperative. If he was a flight risk, or if he didn't cooperate with at the time, that would have been written in the reports, and it's not. It's not written in the report anywhere that he was uncooperative or anything else. He absolutely came back and faced the music and got arrested, was even in the front seat of his vehicle, handcuffed in the front, from what I recall. Maybe he was in the back, I don't remember. But obviously he came back, to face the charges. So he is not a flight risk. And again, he doesn't have anywhere else to go. As I said to the court already, there are so many different things the court can impose. You can take his driver's license away, you can take electronics away, make no contact order. He is not a flight risk. He's not going anywhere. And again, going back through the answer to,
Well, what was he doing in Virginia? And how long was he in Virginia? And did he end up in Indiana? And how long was he in Indiana?
you probably got to drive through Indiana to get to Virginia, I think.
No, being a Maryland Terrapin, you don't have to do that.
I don't
In fact, you stay as far
I'm
away
not
from
from
Indiana as you
Michigan,
can.
I'm not from Michigan.
So, yeah. So what was he doing in Virginia?
And he just reminded me what he went down there, because I think that he had friends that were in Virginia, and he went down there to visit a friend, and he came back. So it's like a vacation that he was on, which is allowable, Judge. I mean, if you're not
I'm
under,
not saying it's not allowable, but counsel, you're leading this court to believe, and I'm not saying, and it may just be semantics, but you're saying to me he's only resided in the state of Michigan. I get the whole schooling thing, but that's not true. He resided in the state of Virginia. Then when all of this is at least brewing, from what I understand, and is out in the community, he then takes back off to Virginia and or Indiana for at least some, I don't.
from my understanding, it was only a week, Judge. Only a week. It wasn't even, I don't even think it was a week. Because he was back here, I think he was arrested on the 20th of October, was the arrest date, and I think that it was, it was only for a few days, maybe from the 15th of October to the 20th, something like that. Might have been a little longer, but I'm not sure what the dates were, but I know that he drove back on his own accord and came back. So there's nothing that anybody can say to the contrary to that. And, if he drove back here knowing that there was an investigation going on, if he was going to be a flight risk, then why would he drive back here? His intention was to go to Virginia and say, I'm not going to face the consequences, then why didn't he just stay there? He came back to face the charges. So, the flight risk thing doesn't work. And again, Judge, I'm not trying to play semantics on the court whatsoever.
No, I'm not saying that you were trying to play a game with it, but I'm just saying, by interpretation, certainly, of what you're telling me, gives me a different picture. That may just be how we view the world. That's fine. But prosecutor does bring up a good point, and I don't know what your response to that would be, that at the time he's arraigned, there are a certain number of charges that are pending. The bond of $3 million is set based upon those charges. Additional charges are then filed. His bond remains the same. They don't ask at that point to up the bond. But as it sits before me right now with basically these competing motions, given the charges, and it kind of shifts in terms of one's burden, why wouldn't I grant the prosecutor's motion to deny bond unless I have before me something that is clear and convincing that he is not a flight risk and that he is not a danger to the community. Why wouldn't I?
And I would agree 100% with what you're saying, Your Honor, except for the fact that all the bullet points I've already presented, I don't want to beat a dead horse here, but again, if you look at the answer in her complaint, that she can neither, admit or deny, for one, the meat and potatoes of my argument in 6, 7, and 8, she doesn't admit or deny any of those. So if you can't deny them outright, then your case must not be that strong if you can't deny it. She obviously doesn't have the proof.
Yeah, but that's not my standard, is it? Under the rule? I mean, the charges have been brought, and if I believe that there's a likelihood of conviction, then certainly I can go one way. But on the charges, certainly I could deny bond unless there is clear and convincing evidence that he does not pose a danger to the community and or flight risk.
Right.
And I'm getting, and counsel, and I'll just tell you, I mean, I sit here and I cannot certainly predict the future. That is not my job. But I certainly have to look at a person's behavior to try to assess what is the likelihood that that person will do it. And I'll be honest with you, I'm not getting really satisfactory answers to his whole Virginia connection, to where was he? And you're saying it's a vacation or whatever, but okay. And the contact with individuals and what he's saying to those individuals, knowing this is going to happen. I'm a bit hard pressed to say that that person doesn't pose a danger to the community in terms of what he will do. But I'm more than willing, I mean, I'll stay here as long as I have to. I'm more than willing to hear all of that. But those are things that go to those core issues of, does he pose a flight risk? I understand he has no criminal record, so I don't have that. But when all of this is going on, why does he take off to Virginia? And then these people, maybe that's wrong, who are so close to him, they're not really sure where he is. Is he in Virginia? Is he in Indiana? Chief suitcases for 5 days? I don't know. But depends, I guess, on how you pack.
I lived with my wife before either.
Pardon? Well, yeah. But that's a problem for the court.
Well, the only thing I can say, Your Honor, to this is this, if the guilt was evident and the presumption was great in this case, we would have way more evidence to look at.
But counsel, here's the thing. As Ms. Reiser is pointing out, if one of these victims gets up and says, this happened to me, and lays out a series of events and a series of facts, then certainly he could be bound over to stand trial. And certainly a jury could convict solely on that. I mean,
you convict on circumstantial evidence. I don't disagree with you, Judge. Circumstantial. I can make an allegation against anybody.
correct. But then counsel, and I get that charges, the number of charges don't matter. But what the court also, in looking at that particular issue, does have to take into account is the people's rendition in their motion. There is this repetitive predatory behavior, realistically, as our society is under circumstances that are really troublesome because of his position and these young adults. But it's not just one. I mean, there are just these numerous people, alleged victims, but an odd commonality to what they're saying. And maybe not so odd, but there's certainly a commonality as to what they're saying. That anything else you want to say as to, under the rule, as to whether or not the court should strongly consider the people's request that I deny bond? Is there anything else you want to say?
Your Honor, I just think that, based on what I've already presented to the court, with the low risk coming from a doctor in your jurisdiction, that maybe he's even been in front of this court, I don't know. But I mean, obviously she put him as a low risk. I think that should weigh heavily on the court. I think that, his prior record, the fact that he doesn't use drugs or alcohol, that he has his entire family here, that he could get a job, that we're willing to let you take the electronics, no contact order. I think that,
if he got a job, counsel, what would he be doing?
he does music, Your Honor. I mean, he could,
Would he be around people, young people? Or people younger?
not have to be around any young people, and the court could order him not to be around. That wouldn't be a problem. It's not any problem whatsoever. If you want to put him on house arrest, put him on a tether, he's willing to take that as well. You take his driver's license away and make him have to get driver's.
Counsel, I'm aware of what I should or could do.
I'm just saying that, Judge, there's ways that the court could obviously make assure that if he bonded out, that there's not going to be a threat to the community and he's not a flight risk. And I think that we've submitted many letters of people that have known him his entire life, friends and other people. I mean, he's got a whole courtroom of people on this side over here that are here to support him. And, and just the fact that he came back from Virginia and drove back here, which he didn't have to do. If he was going to be a flight risk, why would he do that? He's here. He did not try to stay gone. He came back saying, hey, I got to go back up there and I got to pay this fee. And he came back. And that should be the telltale right there, Judge. I think that, weighing these factors into place and going, okay, well, you might be a flight risk. Well, anybody could be a flight risk. Anybody. You could have a, spitting on the sidewalk charge and be a flight risk. But, I understand because of the type of charges that we're looking at, it's going to be scrutinized much harshly. And again, I think that we presented enough to this court, and getting a doctor to come in and see him in the jail and going through all these different things that we did. And again, this is my first try at a bond with this court. I didn't represent him at the arraignment. This is the first time it's been addressed in almost 105 days. So, this is our first shot at, asking this court to reconsider a $3 million bond. This family doesn't have $3 million to post a cash bond on this type of case, Judge. And, again, it's tantamount to no bond. So, and it's not
which can be appropriate in cases like this. You keep saying that, counsel, but I mean,
if the evidence is great and the presumption is great, if the guilt is evident, then yes. But again, Judge, you've even said that, it's a circumstantial case at this point.
I haven't said that.
Well, I'm saying this.
I did not say that.
I know. I didn't mean to say. I'm saying that it's a circumstantial case at this point. And so, if the evidence was overwhelming at this point, where we had all this stuff that was just coming at us left and right, obviously, I would be in a very different position. If I didn't think I, had to hang up here, I wouldn't be doing this right now. But I've looked through all the evidence. I've seen what they have. And I mean, obviously, my client's innocent until proven guilty in this case, and he has a right to go to trial if he wants to go to trial. And obviously, he has a right to go through the preliminary examination, and we're going to hear from witnesses. But again, putting a $3 million bond on a case where there's not any CSAM and there's 33 counts that involve CSAM, or a lot of them anyway, not all of them, but it's just one of those things that, I think the court should consider that, a reasonable bond in this case, which is guaranteed by our Constitution and the Supreme Court the Court of Appeals of Michigan, the site that I cited to the court earlier, guarantees you a reasonable bond. And if the guilt is not evident and the presumption is not great, then you have to move on to the next prongs, which is whether he's a flight risk or danger to the community. And then even if the court deems that doesn't mean no bond. Obviously you could put a higher bond on him, but again, an unreasonable bond for a guy that's indigent at this point. He doesn't have, his truck got repossessed. He doesn't have a home. He doesn't have anywhere to go. All this stuff is gone to four winds. He doesn't have a phone or anything else. He doesn't have a computer. He doesn't have anything. So he's indigent at this point. His support is coming from outside influences, outside people or whatnot. So he doesn't have two nickels to rub together. So at this point, Judge, what I'm saying is that I think the court should look at all those factors that, it takes to be a flight risk. You got to have money. You got to, people don't pick up hitchhikers anymore. It doesn't work that way. I'm asking the court to consider it. I think that our request for a lower bond is reasonable based on the circumstances.
Anything additional from the people?
I do, Your Honor, I do. It is not disputed that after these allegations started to surface, but before the defendant was arrested, that he left and went to Virginia. Whether he went there for vacation or to dispose of evidence, he left the state of Michigan. When the defendant was arraigned and charged, additional victims came forward. And I am going to provide the court with an offer of proof of what one of those victims will testify to. And at the conclusion of that, I will ask that his bond be denied.
Go ahead.
The victim was jealous of Zach because Zach was a cool guy of the church. Everybody talked to Zach, and he seemed like he was a safe space for people. The victim got an iPad Touch for Christmas when he was 14 years old, and he got Snapchat in February of 2015. His parents did not want him to be on social media, but he defied them and got a Snapchat account anyways. The victim's handle on Snapchat was this. Zach, the defendant, added the victim on Snapchat, and they talked on Snapchat. Around June 2015, the defendant asked the victim on Snapchat if he had abs, and he asked for a photo of the victim shirtless. The victim sent the photo, and Zach told him to delete the photo from his phone. The victim did this. A few days before the first incident, the defendant asked the victim on Snapchat if he knew what a blowjob was. At that time, the victim kind of knew what it was. The defendant asked the victim if he would ever want one. The defendant offered to go on a drive with the victim and they could listen to music and talk. They hung out alone only on 2 occasions. The first incident was a Saturday night in July of 2015. The victim was 14 years old. He remembers this day because he went to church the next morning. On Snapchat, the defendant asked the victim if he had ever gone out late at night. The victim was bored and wanted to go out. In the middle of the night, the defendant drove to the victim's house The defendant was driving a smaller sedan. The victim snuck out of the house and he got in the defendant's car. The defendant was in the driver's seat and the victim was in the front passenger seat. The victim remembers where they drove, on Calder Court, and parked on a street south of Harper Drive, so they were still near the victim's house. The victim was wearing loose shorts and he was a virgin. The defendant put his right hand on the victim's left thigh and began to rub it up and down his leg. The defendant asked the victim about blowjobs. The defendant made it seem like blowjobs were a thing that he did with his friends. He called them bro jobs. The defendant touched the victim's penis over his short and with his right hand. The defendant used his right hand to pull down the victim's shorts and underwear to his feet. The victim said he froze out of shock because he didn't know what to do. After the defendant pulled his underwear and shorts down, the defendant touched his exposed penis with his right hand. The defendant leaned to his right and put the victim's penis in his mouth in a sucking manner. He sucked on the victim's penis for 3 to 4 minutes. He stopped sucking on the victim's penis when he ejaculated in Zach's mouth. The defendant asked if he was okay and the victim said he did not know. The defendant asked if it felt good. The victim said he felt weird. The defendant told the victim he did not have to do it again, but he wanted to give him a space to feel good. The victim asked if he could go inside. And the defendant was okay with that, so the victim got out of the car and went back to his house. Said he could not sleep that night. The next morning he had to go to church and Zach was there. They did not talk about what happened the night before. His parents didn't know he snuck out. The victim said he was scared because Zach was a bigger guy. The second instance occurred in 2016 when the victim was 15 years old. They were still on Snapchat, and the defendant alluded to engaging in more sexual activity, but the messages did not use the word sex. The victim would confide in the defendant about getting in trouble with his parents, and the defendant picked him up in the middle of the night. He instantly came down to get the victim. In the same sedan as the incident before, the defendant was in the driver's seat, the victim was in the passenger seat. They drove to Oakwood Church's building, currently the Washtenaw Christian Academy. They pulled into the parking lot. The defendant asked the victim if he'd ever given a blowjob. He said he did not. He kept pestering about giving a blowjob, and the victim was hesitant and told the defendant he felt weird. The defendant pulled his own pants down and said that the victim should suck his dick. And the victim said, I don't know if I want to. The victim froze again and the car was silent. A few seconds later, defendant started masturbating while the victim was sitting there. The defendant whispered to him, you should help, and the victim didn't move. The defendant put his right arm around the victim's shoulder and neck. The defendant pulled the victim toward his lap, and he felt like he did not have a choice. The victim sucked the defendant's penis for about 2 minutes. The defendant had his right hand on the back of his neck, and if he tried to sit up, the defendant pulled him back down. This ended when the defendant ejaculated in the victim's mouth. The victim turned to the right, opened the passenger door, and threw up. The defendant asked, why'd you do that? And the victim did not respond. The ride home was silent. He dropped the victim off. The victim did not sleep that night. He had nightmares. He was scared for his life because he thought Zach had a gun. Before this, he said Zach always had a gun on him, but he did not see a gun on this night. His parents didn't know about it. They forced him to go to church. He would see the defendant at church every time. The defendant would tell the victim they shared a cute little secret. In a span of a few months after the second incident, The defendant texted the victim to see if he wanted to meet up, but the victim declined each time. Then the defendant started to ask him for videos of him masturbating. He didn't send any. The defendant in June of 2015 asked the victim if he could ever send a nude photo before. The defendant offered to send the victim a photo of him. The defendant said he would pay him $20 for the photo, so the victim sent the defendant a photo of his penis on Snapchat. The defendant gave him $20 cash for the photo the same night of the July 2015 incident. During the trooper's interview of the victim, he teared up, his body shook, and he took a deep breath in long pauses. He said these events were hard to talk about. We're asking that the bond be denied. That's one victim's testimony that I anticipate you will hear at this preliminary exam.
Of course, we're going to take a brief recess, read over the documents, the letters that you sent, make sure I have that, take a look at it. I will come back and give you 14 minutes. Come back out. We're back on the record in the case of the People's State of Michigan versus Zachary Radcliffe. In this case, there are, in essence, competing motions regarding the defendant's bond. The defendant is asking that his bond be reduced, and the people are asking to the contrary that his bond be effective, well, not effectively, but denied in this case. The court rule is very clear and very specific in terms of when the court can deny bond to an individual. There's a statutory section which applies to it, as well as a court rule. Specifically with reference to the court rule, the court may deny bond to a defendant that is charged with criminal sexual conduct in the first degree, armed robbery, kidnapping with the intent to extort money or other valuable thing. Thereby, if the court finds proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person, or what one may say, a danger to the community. The court can take a number of factors into account, and I've given, I think, each side an opportunity to respond to the court's inquiry as to what was going to be important in terms of the court's deliberation. People have done, well, both parties have done an excellent job in laying the issues that the court needs to decide before the court. I would say that the people's rendition of the statements and stories, at least the minimal synopsis of the statements and stories of the alleged victims in the case, are indeed compelling to the court. And one of the first inquiries that the court had was, as the court sees the whole thing, what really is a grooming and predatory behavior as you see each of these incidents. The court does take into account also that the defendant's position within the church and access to the youth play a factor in that, as it does in cases where there are children involved and certain behaviors, threats, if you will, enticements, other things can come into play. what is also of note, and something that the prosecutor brought up, and I think does bear noting, is that the defendant's bond initially, when the initial charges were filed and the arraignment had, was set at the $3 million, the current bond that it is set at. Did not take into account the additional charges that came forth. So this is really, in essence, the first addressing a bond with the additional charges of the additional individuals. I say that because I want to make it very clear that any change by this court is not based upon it's based upon the motion, not based upon any abuse of discretion by the magistrate in terms of initially setting the $3 million bond. But the rules, in essence, well, defense counsel is correct in pointing out that one looks at an individual's release and their ability to have bond or to be in a position to post bond and not restrict their liberty, except under those limited circumstances. And then it is almost as if and it is up to the people at that point to show that the defendant should be incarcerated. In limited circumstances, that in some ways shifts the burden in looking at certain things shifts. For example, in a crime of treason, violent felony where the other predicates are met, and then in certain types of cases where there is an analysis of whether guilt is evident or where the presumption is great. Given what this court has heard and the motions that have been filed and the information that has been put before the court does find that there is a great presumption that the people have established a great presumption of the defendant's guilt in this case. I would also indicate that the court is taking into account that the behavior is indicated, at least is laid out here. And I don't know what would happen during the course of testimony, but what has been laid out shows, I don't even want to say classic predatory behavior, but it in a lot of ways is, where individuals are basically these victims are placed into that position. Certain threats, either said or unsaid, are then placed upon these individuals, and then these individuals don't come forth. As the proffer indicated, that was put forth by the people. If that's true, and if the evidence, I should say, bears that out, one can see what the court is talking about with reference to an individual that is a young person who is forced to engage in sexual acts, who is then that next day has to see that person in, well, places, a church, and that person being in a position of power or authority. Been doing this a long time. That whole concept may seem like it's just something that just happened. Frankly, when one looks at it on the surface, that it's actually, if this is a circumstance where the two incidents, that's all that I had necessarily before me, occurred, that's not by accident. That is, that whole series of things is by design for a very good reason, because that stops this person from saying anything. Doesn't say anything to the parents, doesn't say anything to the people in church, doesn't say anything because of where this happens. And the longer that goes, it becomes more difficult for the person to say so. In just listening to that, looking at what's been laid out by the people, the court, as indicated, does find that there is a great presumption of the defendant's guilt. It then shifts to show by a higher standard than normally would be applicable in a bond argument of basically a preponderance of evidence, but it shifts to a clear and convincing standard to show that the defendant is not likely to flee or does not present any danger. And that really does shift, in essence, to the defendant to show that, or at least put forth some evidence to the court where the court could conclude that. This court does not conclude by any stretch of the imagination that the defendant is not likely to flee. The court believes that the defendant is in a position of potentially facing life sentences. That also there is a circumstance, and it's a bit unclear, a bit murky, but where he knows that he is subject to at least an investigation and flees, or at least leaves the state. Oddly, where the parents, or those that most likely would know where they are, where he is, don't know. And he is there. Counsel may make a good point that when the very fact that if he were going to flee, that he comes back, under what circumstances and for whatever his reasons are of coming back, I don't know, and maybe that's to be told, but this court views that as something where clearly the defendant has connections in other states that he could flee to. I think that the laying out of the number of victims, and not necessarily the numbers, but the number of the acts, make it more likely to this court that the defendant would flee or could flee to that. And the court does believe that he poses a flight risk. I also do believe, because I think it becomes a bit difficult when one is trying to address, does this person pose a danger to another person and or to the community? This court does believe that this defendant, given all of the circumstances that the court now has before it, does pose a danger to the community. I've read all of the letters of support that the defendant does have, and people have good things to say about him. They have good things to say about his family. I make note of one thing that the prosecutor said, and it doesn't seem like it's much, but for this court it was much, where in talking with the Michigan State Police, she either blurts out or says that her son is leading a double life or a separate life. I don't blame her for saying that. I think it may have just been something that she said when she sees everything. And I think that that's true in this case. And so I also think that there isn't, given the magnitude of what the defendant is accused of in this case, that while the court has many tools at its disposal, the court doesn't have the, I don't think, proper tools that would be able to monitor and prevent the defendant from hurting other individuals or engaging in this behavior with other individuals. The only way the court would have to do anything along those lines is certainly to order that, but that doesn't mean that the defendant has to follow it. And then we don't know until somebody else's mental health and or physical health is damaged that it has occurred. And this court is not going to take that risk given the circumstances and what the court is looking at. Taking all of that into account and looking at everything, and now looking at this case with the number of charges, the number of alleged victims, the court does not believe that the $3 million bond, which was initially set, is an appropriate bond, and that under the circumstances, the court now has heard them and now knows the defendant's bond ought and should be denied. And so therefore, I will deny the defendant's motion to reduce bond. I will grant the people's motion to deny bond. Defendant's bond is denied. We are also set, go ahead.
Thank you.
We are also set for PCC. Are we ready to proceed to the next stage in this matter?
Judge, I was gonna ask the court, will you do a written motion on that order that you just made?
You mean a written order?
Yes, sir.
I usually do not prepare a written order. If you'd like to prepare one, you may, and I look at it and sign it. But I mean, in terms of, there'll be a written order denying his bond. But
No, I understand. I just wanted your written findings in the order that you put on the record.
I'm going to let the record stand. If you want to draft an order, counsel, I will be more than happy to look at it and sign an order if it's appropriate.
Okay. So as far as the PCC goes, again, we just got their supplement report yesterday, number 12, where the last one we were here on the 9th, that I had asked the prosecutor specifically if there were any more warrants out. There was not. Apparently there are. There's Snapchat warrant number 1 and 2. Based on that report that I just got yesterday, there's Beth's phone. I don't know what that is. And then she's got also on there that the MacBook Pro, the black MacBook, and another phone. Apparently they're still doing some forensic stuff on that. I'm also going to address some of the older stuff that we previously asked for, which she alluded to today, I think, which was the wired conversation between
What conversation?
wired. I've looked through my stuff. She can direct me to a time or date stamp or in a date for that particular conversation that was made between Priscilla and Mr. Radcliffe. I've looked through all my stuff.
You use the first name, Priscilla, being
Berg.
all right, go ahead. Oh, I got you. The X in him.
Yep. So there's apparently a conversation that was recorded that I don't have. I don't know if it's something that they've sent and it's in something else possibly, but I pretty much have gone through everything that has been sent and I have not seen that. And then we've also asked for the victim advocate's notes, which were done by Megan Calamita. Whether they're exculpatory or inculpatory, doesn't matter. We're entitled to them. And we have a right to those notes. If any of the victims made statements to the victim advocate, I would ask for those notes. And I previously asked for that information.
So what I have here is I have two things: the wired communication and victims advocates notes. Is what you're.
Those two things, but also, Your Honor, are we going to get Snapchat warrants? That I thought warrants were no longer in play, but again, we just got the sub report 12 yesterday, which says that these are outstanding. The Snapchat warrant 1 and 2. So I didn't think that there was any more warrants out there for material. If they are, that's fine. I just, I thought that we had already answered those questions.
Mr. Adams.
We would ask that a preliminary exam date be set. I believe that we'll need a separate date because of the number of witnesses and the length of time that it will take. So I would request that it not be set on a Tuesday with other exams because of the number of victims that are set that will be testifying, I should say. The recording should have been sent, and I'll confirm with our discovery clerk if it went evidence.com or if it's something that counsel needs to pick up, but it is item 22. The recorded conversation between the defendant and one of the witnesses. So he should have that, and I'll double check. And the,
So you believe what's been referred to as the wired communication has been sent?
it should be. I don't know if it went on evidence.com. It's listed as item 22, so I have to check with Ms. Warnick because she sends everything out. I don't know if it was mailed on a DVD, but that should have already been
Gone
discovered.
to, okay.
It hasn't, it should, that's it. I don't believe, I don't have, and I don't believe that the victim advocate's notes are discoverable, so I would ask for some authority on that. I don't know how they would be relevant.
I don't know how they would be discoverable either. Do you have anything on that?
I don't have, I think I may have something, Your Honor, that I can forward. I could file something as a supplement,
That's fine. I mean, on first blush, I almost look at it as though it would be getting an attorney's office personnel notes regarding conversations that they have with clients. And it would seem to me on first blush, I'll give you an opportunity to get something to me, that's going to be privileged information and that wouldn't be released. So subject to getting anything else, that's going to be my ruling, that those notes that with regard to victims from the victims advocates would be privileged communications because of their contact with the prosecutor's office and their work product, which may be part of the prosecutor's office. So that's the theory that I'm operating, but certainly counsel, feel free to file whatever is necessary. I was a bit confusing at the last hearing because I wasn't sure what warrants we were talking about. But I guess counsel has just received another report.
Supplement 12 is not a warrant. Supplement 12 is an interview with a witness about a conversation. Supplement 12, January 13th, 2025. A witness called to talk about disturbing comments that the defense father made. That's supplement 12. It has a journal, but it's barely a page long.
Hold on,
The report was sent over there.
hold it, because I want to make sure we're talking about the same thing. Because when I listened to Mr. Thomas, it sounds to me like you were saying there was a warrant out. Information came back from that warrant. Created a report.
Forensic analysis of the defendant's devices. I don't know the time limit on that. If we don't have passcodes, we could.
No, I get that, but I want to make sure, folks, that in regard to number 12, that we're talking about the same thing. Because as I understand what Mr. Thomas is saying, and correct me if I'm wrong, Mr. Thomas, it seems to me he's saying that there was a warrant that was out, that warrant netted certain information that then was placed into some supplemental report, which was just produced.
right. I think it's at the end of 12. I looked at it briefly. I know it said something about the Snapchat warrants were out. It's I think toward the end.
So the supplement 12 is maybe 2 paragraphs. It's a witness that called to talk about some disturbing comments that the defendant's father made at 125. Status open, the case is open, pending the CCU's forensic analysis of the defendant's devices. There is something they're trying to pull off Beth's phone and search warrants for Snapchat 1 and 2. So those are outstanding things that the police department is waiting on, if you will.
Got it. Okay. So that's how I get to the Snapchat. The best. Okay. Now I think I understand.
The search warrants have been served and we're waiting on the return.
Waiting on the returns. Got it. Okay. Now I think I understand. So there was a report generated. At the end of that report, it just lists what else is out there that everybody's waiting on.
Correct.
And that's where the snap. Okay. Now I see where we are. So do we have any indication of when that might happen. I thought that's what you were gonna say. Okay. So with that, counsel, I mean, I can set a preliminary exam date and what comes through, and I'll entertain whatever comes at that moment, but I don't know what's gonna, I mean, I have no idea what's gonna come of that. But what's your preference in terms of?
I mean, I'm fine, Judge. I think that, I mean, what I don't want is to get hit at the last second with a piece of evidence that we didn't get a chance to look at or to scrutinize, or, obviously you would understand that. I mean, you work on a strategy and, and then all of a sudden somebody produces something.
No, I got you. And I guess what I can do is I can set a prelim date. I can then indicate that if something is there, then certainly I would allow you to make that argument where it would cause a problem for you, and I'll deal with it how I have to deal with it. But I think at this point we have to move this case along. So I'd like to do that. With the understanding that the other forensic, the electronic, the devices may not be available at the time of.
I mean, as your honor knows, these devices, it could take 2 years for the computer crime lab to get into them. So we can't adjourn, but we could be adjourned for another year, another 2 years. I just
Not doing it.
don't have the time.
I would just ask the court if, if it's not producing, they get it at the last minute. Either we're going to get continuance or not.
Right. I mean, well, counsel, just so that you understand how I work, I'm not going to let anybody. I expect counsel to do their due diligence in terms of any evidence that comes for us. So I don't expect somebody to lay out a piece of evidence if I haven't had an opportunity to do that. But I would not, I think counsel should be very clear. My expectation is that whatever information has to be given to each side will be given in ample enough time where the other side can do what they need to do. If they don't, if you run into that situation, I will always hear one's argument about why I can't proceed if something has just come to you, you haven't had a full-blown opportunity to do that. I'm not going to do anything that puts anybody at a disadvantage. So when would we like to do this?
Do you have certain days that apparently you do them on Tuesdays, right?
Well, yes, but that's rotating. But what Ms. Reiser indicates is that it's going to have to be a special day, so it's going to come off of my very skimpy docket I have to give.
Well, and Tuesday there are several other.
Yeah,
cases
yeah,
that-
it's not going to be a Tuesday.
Judge, I don't know if you'll do this, but can we do it on a Friday? Is that a possibility if we're gonna? Just asking, only because.
No, I hear you. Okay, so just what my reluctance is I have housing dockets on Fridays, which are intense and very long. And when I put them over, that means the next following week is even longer. And are Mondays bad for you? Or
Just like any other lawyer, I mean, that's, I'm gonna have to make sure that I get everything cleared off my docket, on a Monday. But I'm not overly worried about it, Judge, but.
okay. Mondays work better for the court. I can tell you that. Ms. Reiser, what about Mondays regarding you?
I could find a Monday.
All right. So if we work with Mondays, why is this that?
This is a trial. That was the Simpson.
You like the
Trials in the morning.
Do we have anything set?
February 24th?
Oh, February.
Think of something else.
It really shouldn't, but. Just, that's, yeah, okay. So I have available Mondays. I have February 24th, March 3rd, or the 10th, and whatever day we just clear out whatever else I have.
I am available February 24th.
The 24th.
That work for it? Okay. Preliminary examination in person will be set February 24th, 2025, 9 a.m., and that is before me.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.